been down in Florida?
Yeah, yeah,
It's not like first generation.
Yeah. Nice in the winter, but it's.
yeah, but I mean, yeah.
It's just not enough.
You look nicer.
So those are floating piers. They drilled them already, you know, like they.
That's a culture.
I didn't wear time, like, I feel.
He's in shorts.
Just all around. Yeah, there. Keep the troublemakers.
Dan would have to take this night up to be here, right?
That's the next question.
I would like, I was gonna bring that up to you, because I was like, wait a second,
We're planning on it.
Okay.
Say you don't want to.
no, I do,
Okay. That sounds good. You can say.
as long as these fine people don't have opposition to it.
What's that?
We're, the board is looking to, needs to reappoint you because your term ends July of 2023.
Oh,
So we'll be making a recommendation to reappoint you next
Uh-oh.
Monday, unless there's any reason that you have, you know.
no, not at this point.
Okay, good. Well, thank you.
Well, there goes our opportunity.
Hey, Claire, can you hear me?
Yes.
Voice from the sky. Sorry to interrupt, but I just wanted to let you know, as a reminder, the microphone on the podium is not operational. So when public comment is made, the microphone that's in the center of the computer desk needs to be moved to the podium.
She already switched it.
Well, we had disconnected that, right? And put it
I
into
think it's
the,
all taken care of.
yeah, the podium is active.
No. Okay. Yep, we're all set. Thanks, Matt.
Okay, this is that.
And Dan may be here.
Who?
Dan may be here, but he'd be late.
I'll vacate immediately. Have no problem at all.
He was trying to get off the boat and sounds like.
Is it possible? Well,
I think it's fine.
Recording in progress. Recording stopped.
okay, why don't we call this meeting of the Wednesday, July 5th, East Bay Charter Township Planning Commission called into session, and we'll start with a roll call, please. Oh, I'm sorry. We'll start with the Pledge of Allegiance, sorry. Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, good evening, everybody. Okay, can we start with a roll call, please?
Yep. Ferguson.
Here.
Richardson.
Here.
Walters. Gonzalez.
Here.
Wassam. Edley.
Here.
And Leonard is absent and excused.
Okay, thank you. Review for the conflict of interest. Seeing none. Approval of the agenda, please.
I'll make a motion to approve the agenda for Wednesday, July 5th, 2023.
Second.
Moved by Mindy, seconded by Carl. All in favor?
Aye.
Approval of the minutes of June 6, 2023.
have an amendment that needs to be made regarding item number 9, where it said a motion was made by Ferguson, supported by Richardson. I don't remember supporting that, and then voting no.
Okay.
I don't know who seconded it, but it wasn't me.
Okay, well, we'll have to check on the record to see how that actually was supported, and then we can correct it.
Okay.
Okay. Anything else? All right, can I have a motion, please?
So we need to move to table it because we need it.
I would table it, yeah, okay. Okay,
I'll make a motion to table the minutes from the June 6, 2023 until review can be made under number 9.
okay. Moved by Mindy, seconded by Rhonda, to table the minutes of June 6, 2023, pending clarification of item number 9 on the support. All in favor?
Aye.
Opposed? Thank you. Okay, public comment will begin at 6:32. This is for anything which is not on the agenda. Any public comment for any item not on the agenda? Not on the agenda.
Hi, my name is Sarah Beatty. I'm the owner of Green Space Preschool, and I'm here tonight in favor of the ordinance amendment moving forward for the child care facility. Children who experience quality early learning and child care programs are 25% more likely to graduate high school, 4 times more likely to complete a bachelor's degree or higher, and earn up to 25% more in wages as an adult, according to Early Champions for Early Learning. From language development to overall health, research consistently finds enrolling children in a strong preschool program in the earliest years is critical for healthy development, growth, and long-term well-being. With this said, preschools and child care in the Traverse City area, and specifically in East Bay Township, is very lacking. According to a recent report by Networks Northwest, there has been a 30% decrease in our child care facilities in the past 7 years, despite the growth of families in our local area. I urge you to not hold this ordinance amendment any longer and let preschool owners like myself move forward in opening to help our community. We heard you when you asked for standards, and with the help from Venture North, you will hear those standards tonight. I hope that they show you that East Bay Township industrial and zoning areas are no more of a hazard than the other zoning areas in the other zoning districts in our area. I would like to highlight that the Business Park District is on the same water supply as all of East Bay Township's private and public schools are on. I would also like to point out that in the Peninsula Business Park, there are no longer any lots available that would be suitable for large industrial-type factories due to how swampy it is. So there is no risk of any hazardous factories being added to the park. In closing, the concern that having child care facilities in the business park area of East Bay Township would take away from industrial businesses was brought up in the last meeting. I would like to point out that the type of building that child care business owners would be interested in buying and using for child care facilities are already being used for non-industrial type businesses, such as insurance agencies, Boy Scout hunts, and pediatrician offices, therefore not taking away from potential industrial business space. Again, I urge you to consider how much of a need child care facilities are in East Bay Township, and please understand that without allowing this ordinance amendment to move forward, there will be no chance for child care growth in our township. Thank you.
Thank you. Is there anybody else?
Without the agenda in front of you. You have to come up to.
You have to come up to them.
I'm here to speak to the Gerald.
Please identify who you are.
My name is Elizabeth Black. I'm a resident of East Bay Township, living on Holiday Road. I'm here to address the Gerald development. I didn't know if this was the appropriate time or not.
No, it's on the agenda, so this is for anything not on the
And that
agenda.
was my question.
Okay, right. Is there Anybody else? Going once, twice?
Good evening. Thanks for doing this tonight. Matt Vermetten, I'm an attorney. I too am interested in the zoning amendments for daycare and preschool discussions, possible action tonight. I'm urging the board to take that possible action tonight by issuing a special use permit to the individual who just spoke. Frankly, I reviewed and I've had communications with counsel, Ms. Teschner and Ms. Hawley. Ms. Hawley appears to be on the Zoom. Pretty extensive discussions with them. I've also talked a couple of times to Ms. Carter. Frankly, I have no objection to the June 26, 2023 analysis and memorandum of law that was produced by your attorneys for this specific project or this specific area of the project. And so as a consequence, I'm asking that you adopt that and incorporate that. The only issue that I had initially was a baseline environmental only for this site, because this site represents an insurance agency. That's all this site has ever been. But candidly, if it's good for the goose, it's good for the gander, and if we're going to do that for everyone, I think it's important to do it for this one as well. The state of Michigan already requires a health safety analysis of the site for their licensing perspective. So I'd ask that that you consider highly the special use permit, perhaps making it contingent upon the securing of the baseline environmental.
Thank you. Okay, any other comments on items not on the agenda? Okay, seeing none, we'll close the public hearing at 6:37. Okay, correspondence, we have all the items listed.
Yeah, there's 2 items in your packet, and then there is additional correspondence that came in over the last few days since the packet went out. One was from Judy Nemitz regarding the proposed text amendment, and the other one is from a resident regarding the site plan review 6-23. Those are on your desk.
Okay. Thank you.
And then you also received electronic copies of the updated proposed text amendment, as well as updated memo from Olson Bizdoc. So those are in the electronic version of the packet and also on your desk.
Thank you. Okay, reports, starting with the township.
I always forget about this part. Oh, goodness. Sorry, can you help me?
The township board approved the parking standards at the last meeting. And so that's official now. And then the short-term rentals were the...
Short-term rentals are the big ticket item. At the meeting last month, it was voted on that we change the length of stay. Currently, in the current ordinance, it's 1 and 4. It was voted to put it to 1 and 7. So 1 stay of 7 nights or less for a short-term rental. And that was introduced last meeting, and it will be on the agenda for public comment next week. And Beth just put my packet in a box if that's what people were seeing me thumbs upping Beth. So, meeting is next Monday.
Okay, thank you. As far as the ZBA, we had a dimension request for a garage in the Lakes area, but that it was not approved. So that was the only item that we had on the ZBA, and there is no meeting of the ZBA this month, so. All right. Let's see. Claire?
Just one update, the Planning and Zoning Department, we received 2 grants for US 31 Beach District Visioning. One is from USDA, and the other one is from the Michigan's Coastal Management Program. So we're super excited to officially kick off the visioning process. That's going to be July 27th. We have a business owner networking event at the new conference center on the corridor, and expecting pretty good turnout, as well as some preliminary visioning and input from the business community and stakeholders. And yeah, we'll continue to provide updates and opportunities for engaging, but the focus will be on developing a vision for public infrastructure along the corridor, as well as working with the business community on some marketing and promotion of that corridor.
Great, thank you. Okay, let's go to item 9, which will be the beginning of the business, and A will be the zoning ordinance subcommittee appointment. Claire?
So I put this on the agenda. We, as you know, we are down one staff member. We don't currently have a zoning administrator, and so our zoning ordinance subcommittee has been a little bit small, because we have 5 on the subcommittee. We're down Preston, so we only have 4. So if we have one person who's absent, or even 2, then I would like to have more people on the subcommittee. And so I was thinking, just because this subcommittee is really drafting the zoning ordinance for the plan that's going to be most used by the Planning Commission, I'm recommending having 2 planning commissioners serve on the zoning ordinance subcommittee. Right now, we've got Paul Gonzalez, who provides great perspective from Planning Commission, as well as he's on the ZBA. But I would love to have the Planning Commission appoint an additional representative to serve on the zoning ordinance subcommittee. And when we have once we've hired a zoning administrator, we'll have them as well. So it'll be a committee of 6 as opposed to 5, just to have more participation and ensure that the meetings are well attended. And
Okay, thank you. That being said, do we have any volunteers?
What's the time commitment?
The time usually, it's at this point every 3rd week that we have it, usually on a Wednesday morning, every 3rd Wednesday, 8:30 in the morning, and usually ending about 10:30, maybe 11, but mostly by 10:30.
And we're anticipating that these meetings will continue until probably September, and then we'll have a full draft ordinance for the Planning Commission to review. So it's not forever, but it would be for the next few months through the summer.
Yeah. I'd just add to the fact that from a standpoint of the work that we've done so far, it has been pretty interesting to see where we have made some changes and actually clarified a lot of items as far as the ordinance changes are in the works. In addition to that, a lot of the legalese has been removed, so it's much more readable as far as following through what is required in the ordinances. And we've done a lot of work, but we have a lot more work to do. So.
I think I can probably make that.
Good. Excellent. Excellent. So we need a motion for appointment.
I'll make a motion to appoint Carl Ferguson to the subcommittee. What's the zoning ordinance subcommittee?
Support.
Okay. Motion by Renee, seconded by Mindy, to appoint Carl to the subcommittee for the zoning ordinance rewrite. All in favor?
Aye.
Opposed? Congratulations, Carl. Welcome aboard. Yes. Okay, consideration of zoning amendments for daycare and preschools. Open up, Claire.
Okay. So at the June meeting, there was some detailed discussion on this topic. You reviewed staff recommendations to some additional districts that would permit daycare centers as well as group daycare facilities and educational facilities. One item that the Planning Commission was looking for some additional information on from staff was an inventory of the current industrial park. So there's two. We took a look at the areas, all areas that are zoned industrial. We didn't include the areas. There's some professional office areas in Peninsula Business, so those were not included in these statistics that I'm going to provide for you. But we've got 16 businesses that are related to manufacturing, processing, and use of hazardous material out of those two business parks. And we have 13 businesses that are currently zoned industrial and operate as professional service or something similar. So I thought it was interesting that of our zoned industrial sites, it's about 50-50. We have more that are manufacturing leaning, 16 versus 13, but we still have a lot of sites that we've got professional office and similar uses that are gravitating to that. I think you'll see that those sites have been developed. They've got water and sewer. They've got the infrastructure there, so it's easy for a business operation, professional business, architect, those types of services to go in and have a little bit lower startup costs than clearing a new site. There's 13 sites that are currently vacant that are zoned industrial between the two industrial parks. But again, we have limited industrial in our township, so those are 13 spaces, and there's not too much else beyond those 13 spaces. So you'll recall, after deliberation, the Planning Commission directed staff to develop standards for preschools and child care centers. So you're looking for more guidance on specific standards, specifically under the consideration of allowing daycare centers to operate in industrial districts. So the township received some grant funding from Venture North to work with the environmental attorneys at Olson Bisdock to develop model ordinance language. So Abby Howley is here representing Olson Bisdock. She's going to talk a little bit more about the standards that they've developed. And I will mention that similar to the parking standards that were just adopted, you'll have the opportunity to reevaluate these standards as we rewrite the zoning ordinance. So this could be, I think that we want to put standards in place that will work long-term, but if there are any tweaks that we want to make, we're in the process of rewriting the zoning ordinance right now. So tonight you have the opportunity to review and discuss draft language. If you're comfortable, you can schedule a public hearing for August 1st. You can schedule the public hearing with the ordinance as presented, or you can make some minor modifications. If you're looking for, substantial overhauls, then we would likely recommend, taking a second look at it before scheduling a public hearing. The other thing that I just wanted to mention, because you got some correspondence from a resident about the group daycare homes and concern about ones that are located on septic systems. So my intent with group daycare homes, which is 7 to 12, those are the ones that require a special land use permit, was to recommend allowing them in all residences throughout the entire township with a special land use permit. So there was concern raised by a resident about inadequate septic system. I spoke today with Craig Preston. He's with Grand Traverse County Health Department, Environmental Health Division. So just to better understand the licensing process. So as a part of the state licensing process for these group daycare homes, they make sure well and septic meet minimum requirements and that they're sized appropriate for however many kids they would be licensed for. And he said that every 2 years they would go back on site as a part of the relicensing and re-inspect these systems. So that's just some additional background information. So I guess with that, I would turn it over to Abby to talk a little bit more about the new language and standards that are presented in your packet.
Thank you, Claire, and thank you, commissioners, for having me this evening. What we prepared for you was a memo, in some parts overlapping the work that staff did. Claire did a really nice job of initially reviewing what the status of your ordinance was, as well as some local townships and municipalities that allow daycare facilities in industrial districts in particular, and whether they have any additional standards in place or rules and regulations. And based on both of our independent research, the outcome is that most do not have additional rules and regulations, and that might not be a bad thing and it might not be a good thing. There's no opinion either way on how they've gone about this process. In particular, when Claire contacted us, and I went back and watched the meeting from last month, there were some questions about if you were going to put standards in place, what should they look like, and how would you tackle that? So we have prepared some ordinance language that allows the township some discretion in what this process looks like for the industrial district. So part 1 of the proposed amendment says that these facilities would not be allowed, or these uses would not be allowed in what's considered a facility. And a facility is defined under Part 201 of the Michigan Natural Resources and Environmental Protection Act, which is a very, very long and comprehensive statute. And in layman's terms, a facility is a location in which the state has identified there are hazardous substances. So this provides the township with a bright line rule that if we know there are hazardous substances at a location, we will not allow daycare or childcare facilities at that location. And that doesn't mean forever. If certain remediation steps were taken to lower the presence or eliminate the presence of those hazardous substances, that location could eventually be used in the future. The second part of the proposed amendment provides the township or the planning commission the discretion that if there was ever a question or if you wanted to do it for every application, you would have the discretion to require further environmental due diligence. And that could be starting with a phase 1, as Mr. Verbetten discussed. And if the phase 1 site assessment flagged the presence or the potential presence of hazardous substances, you could also require a phase 2, which is the actual physical testing of the property in the soil, in the water. It could also be limited to a different type of environmental due diligence that a phase 1 might not cover. So you could require, certain water quality testing steps taken. That would be within the Planning Commission's discretion of what those due diligence steps would look like. And, there's a couple reasons why we made that suggestion. One, because there are certain substances that aren't flagged in a phase 1 site assessment. And 2, phase 1 and phase 2 site assessments are quite costly for an individual to undertake. And so this would be an avenue for the Planning Commission to have options on, what type of testing would they be interested in seeing, but also gives you the discretion to just go with an industry standard of a phase 1 and a phase 2 if that's what you were interested in looking at. And really what we did with our proposed amendment was link it back to industry standards in Part 201 of the state statute. And, I spent considerable time thinking about what this process would look like. And the reality is that as time changes, our understanding of what hazardous substances and conditions changes as well as we get new information. And it would be very difficult for any local municipality or township to decide that they were going to build their own framework and define what substances were hazardous, what would be tested for, what the levels would be, what would be safe, what would not be safe, you would end up with something that pretty much would probably mimic the state statute itself. So it makes the most sense to link back to what's already in place, the state statute, and make reference to industry terms that are understood by individuals who are doing this type of testing, or attorneys who, help advise individuals who are doing that sort of testing, and use the framework that's already in place. It's by no means perfect in the sense that as time changes, sometimes the law is a little bit slower, but it's the most comprehensive framework out there and has standards in place. And so the idea that any site that's a facility would not be used is really eliminating the most hazardous areas. And this premise that if there was environmental testing done, we need the location to be at a level that's called an unrestricted residential cleanup site, or meets those criteria. And the state recognizes that those are our safest locations with the information that we have. So if we're looking at cleaning up a site that has hazardous substances present, the highest level of clean or remedied is the unrestricted residential cleanup criteria. So that kind of provides the township with some framework that would not require them every time there's a request to go through and try to identify what might be present and what levels might be safe, and gives you as commissioners some discretion on, we have some serious concerns about a location, we want certain due diligence steps taken, or this is a brand new, site, there aren't concerns, we don't think that environmental due diligence needs to be done. It provides both of those avenues for you. And then obviously you as commissioners can always bring in other experts if you needed further information on a particular location and what types of testing might be appropriate.
Okay, thank you. Claire, do you have anything else at this point? Okay. Well, then, why don't we open it up to general discussion with the board then?
Come on, Mindy, we know you want to.
So first off, Abigail said that a facility is a site that the state has identified that there are hazardous substances, and it's not necessarily the state that it defines a site to have hazardous substance. It could be anybody, and per the statute, anybody that has knowledge that their site is a facility has obligations under the statute to protect people that are on their property. So I want to make that, and I also want to say this, that a Phase 1 environmental site assessment is for property owners to get all appropriate inquiry done so that they are not held liable for any contamination that's on the site. It is not for protection of the people that are on the site. It's for protection of their finances. Okay, so it's a liability issue. It is not for protection of a sensitive population. It is not for protection of the workers on the site. So the role of a Phase 1 environmental site assessment and bringing it into a sensitive population is used a lot of ways, but it's not really the appropriate use of it. And then if you want me to have a contingent on this site plan that we're not actually looking at, on a BEA, that would be wonderful, because they'd never get it. Because to do a BEA, you have to be a facility. So, and a facility means that there's contamination that exceeds criteria. So Sure, we could do that, and they can't get their site because they don't have a facility condition, and I'm hoping. And they couldn't build there anyway if we put a contingency on that. So there's a lot of words being used that people don't understand exactly what they're being used for. And I'll just point out, if you look at this amendment that we have in front of us, it talks about facility, and it says it's a defined term. But do you know how many times facility is used in this document that aren't talking about that defined term? They call it educational facilities. They're talking about the educational facility, in your regulations and conditions. Facility is being used not as the defined term that it is in Part 201. And that is very striking to me because I think there's a problem there. We need to change the words, and it might be something that has to be changed throughout the ordinance, and that's just a huge dilemma in itself. My biggest concern is that this is something that I've been doing for 27 years. This is my life. This is what I know. But I can't see the township being the ones that is going to be having sensitive populations in industrial settings and be the ones that is deciding what somebody needs to protect these sensitive populations. We need to, there's a reason they weren't there right now. The reason is not so that we can't have child care centers anywhere in the township. It's not because we don't like child care centers. That's not it at all. It's just the appropriateness of where it goes in the township. I'm passionate that yes, we need child care centers. And yes, we want them, child care centers so that people can work and thrive in our communities. But we need to put them in the right places. And the environmental field is complicated. And I just don't think that as a township, this is what we need to be doing. This is why there's not child care centers or group adult foster care homes in these settings already, because they're sensitive populations.
I'd like to chime in because I know that at the last meeting, I was like blown away by all the information you provided. It's pretty amazing. So I didn't even know that was your background until last month. So it's hard because it's like I hear everything you say, and I'm so torn because of that need for childcare. So I guess my question is that we've gone through and gotten this memorandum, which I totally get the use of facilities. That's right in the first paragraph, childcare facilities. We should probably change that to centers. But so you don't feel like by eliminating, let's just say we clear up the facility word and we eliminate facilities that truly match, like what Abigail was saying, that had known substances on it. I mean, in this particular instance, we'll use this person here, that we'll use them because that's going to be in a building that was an insurance. Nothing else has ever been there. Are you saying that you don't feel like in that situation that would help eliminate the, I guess, danger or concern?
So you go back to the fact that we're talking about zoning for the district, right? And we're talking about a district that is known to use hazardous chemicals. And we know that chemicals don't stay exactly on property. They like to travel. They like to travel in groundwater. And vapor is its own animal. It doesn't care which way the groundwater is going. It likes to spread. And it likes to accumulate underneath foundations. And it likes to go where you don't want it to go. So property lines aren't contamination lines. Okay. So I know this isn't, one of the very contaminated portions of the state, but I do know that locally we've got properties that a Phase 1 environmental site assessment, didn't find that the property used to be a dry cleaners, and that I have a client that has spent $300,000 cleaning up just to protect the people that are working in the building. And it's not done yet, and Eagle's not happy. But did Eagle know that the site was a facility prior to him buying it? No, nobody did. So, there's properties downtown. We talk about the PFAS plume that's coming off the airport. We're talking about the TCE plume that's coming off the corner of where the, it's not the ISD now, what is it? It's Northwest.
Career Center?
Yeah, the Career Tech Center. At a TCE plume that's going into our neighborhoods there. We'll talk about the fact that I worked on a site downtown. We were putting in a new building. Used to be a gas station. We thought all the tanks were gone. We did GPR surveys. Couldn't find the tanks. Guess what? We hit it when we put in the sheet piling. It was under the sidewalk. If you think about the school, I can't remember the name of it right this second, on West Bay,
Norris?
Norris Elementary, there's a TCE plume that's under it from Cintas. There's contamination in places, there's that property downtown that is vacant, and it's been vacant forever. And everybody's like, why hasn't this been developed? Because it has a contamination plume underneath it, and put a deed restriction, you can't develop it. The problem with contamination is you can't see it. It's below grade. You don't know where it is. And trying to find it is like finding a needle in the haystack unless you have information for it. The problem with industrial zone property is that there are 13 properties in our industrial parks that are using hazardous substances. We looked at one the other day. They're following all the right procedures and policies, but could a catastrophic loss happen? It could. Could it get to this property? Potentially. And what happens when you've got a school full of children and there's I know it's worst case scenario and I'm being the devil's advocate, but I really don't think that this is the appropriate place for them.
I guess what I'm wondering, well, I guess I have two main things. I agree that we shouldn't be, the Planning Commission shouldn't be a body deciding what standards to put in place on a case-by-case basis, certainly, and whether a Phase 1 is warranted or not. But the second thing is that, as Mindy mentioned, these contaminants can travel, but they're not respecting the boundaries of our districts either. So an industrial site next to low-density residential, medium-density residential, could be flowing there. And right now, we allow daycare 7 to 12 in those by right. So they could be there also. If it's next to the industrial district and something happened. So I guess, I think that I'm a little bit conflicted because I think there's the potential in Mindy's scenario that, we could have plumes of something all over the district or near industrial zones. So, yeah, I don't know. I certainly don't think we should be the ones deciding on a case-by-case basis because I don't think we're qualified, at least certainly not all of us. Maybe Mindy is, but.
I look at it as the way the zoning is laid out now. We have an industrial zone, and right across the street is a school. So there's that potential there already of a sensitive population. You go down the road to the north, and you have another business park, and right next to that is another school. And right next to all that is residential. So it's like, this could be happening regardless. Why are we now just focusing on just these daycare centers? I'll say that rather than facility. And then I go along with, you have these schools that are located nearby all the professional offices, industrial, you have people going to work. It'd be nice if there was conveniently located, you could drop your one kid off at school. If you have multiple ones, you could drop them off at the daycare center, and then you're going to work. And looking at these industrial areas, they're largely undeveloped. You know, if there was a history of this used to be an industrial park and there used to be some, you know, other facilities and you're looking to redevelop it, then yeah. But you're looking at undeveloped land typically where I think it could serve this township well to allow a daycare center in that.
I as well am very conflicted. So Mindy, you said that a phase 1 environmental study may not identify anything, and it's just for liability's sake. So what is the next study? And is that the one that's cost prohibitive?
They both are.
Well, yeah.
So a phase 2 environmental site assessment is when you actually take destructive samples, where you actually take a soil sample, a groundwater sample, a vapor sample. And I will say that a TO15 which is the analysis that you use for a soil gas sample, one sample is $295. Eagle currently is requiring 4/4 of sampling to prove there's nothing there over the seasons. So just one sample.
So you could miss it altogether.
And that's why you don't just take one. So the costs go up very quickly, unless you have something very specific that you're looking for and you know it's there. And that's what I'm struggling with very much so in the industrial park. I will say that our industrial parks are very new comparatively, right? The one is 1991 and the other is 1999. So is there a long history of contamination? I don't see that in our industrial parks. But I do have concerns about them being in the industrial park, and then I have the concerns of the fact that we don't have much industrial land. And we have lots of things that can only go in that area where a child care center, a sensitive a sensitive community can be in other areas of where these other things cannot.
I was looking at in the letter that was given to us by the attorneys, and it puts out under a phase 1 the review, and it has a list about what the evaluator does going through, conducts, starting with just going to the site. And the thought I had on this thing is that this presupposes that all the records are known, that when you look at the history of a piece of property, that you know exactly, how far back to what has happened with that property. And there has been some issues where, in fact, the people didn't know that it was a laundromat, which in turn had put in the grounds. The other thing that bothered me is, and again, I will agree with you, I am conflicted on this. I like the idea. I think it has merit. I think that it's something that's obviously very, very needed. But again, is it in the right place? And there is no guarantee that today you take the samples and everything come out fine, provided you got the right samples, provided you got the right spots.
And the right chemical concern.
And the right chemical concern or identification. And of course, we're not the ones to do that. We can ask for it to be done. But when you have other, I don't want to say facility, when we have other companies in that area that are continuing to do what they're doing, there's nothing that stops those plumes, chemicals, et cetera, from eventually moving into where that facility might be. And again, you know, we're playing devil's advocate here, but at the same time, I think that's what we have to do. I would not want to do something where we would change our rules or ordinances that would eventually wind up with some type of a situation of catastrophic nature. And how we define catastrophic, I don't know. One person may be a catastrophe. So I've been wrestling with this, and I like the idea. I think it's a great idea. I think it's absolutely, positively needed, but I don't think it's in the right spot. That's my only problem. And what we're looking at here is a possibility of, it seems to me, discussing how we can change our ordinances, which would have general applicability over a whole area for right now, one spot, which is almost like a spot zoning, which I don't think that's what we want to do. So I have wrestled with this thing, and I have looked at this thing, and I thank very much, you know, Mindy for bringing out this stuff, and I'm really happy that we have a professional person on this board that is able to point that out. But again, all I can summarize and say, great idea, wrong spot. That's what it is. So that's my 2 cents. I don't know if anybody has anything else that they want to add to that, please. Or counter it, that's fine. That's what we're here for.
I just think it goes back to, like, I don't know if you said it, Stephen or Carl, but so right next door, there's a school. Right on the other side, there's residential. So we could put, you know, we've got sensitive population in the school. We've got residential where they could put a daycare center right next to the industrial. This is where I get conflicted. I totally understand where you're coming from, and I totally appreciate that once we change this, which, you know, obviously other townships have, but they didn't have a Mindy. They didn't have you. But it's like, that's where I struggle, is that, you know, I mean, at what point we can't control everything. Every single one of us should be testing for radon in our homes, but I can tell you most people don't. But it's deadly stuff. I mean, it causes lung cancer, but people just don't think it's real. But it is real, and it comes up a lot here in Grand Traverse County, especially those people that decide to test. But it's just like, at what point do we have to, I don't know. This is where I get conflicted, because I don't know what the state requires. I mean, do they require certain testing? What did you, was it you who said every 2 years, or did you?
That's for, yeah, I talked with the Environmental Health Department, and specifically related to septic and
septic,
well.
that's right,
And they also
that's right.
test for, they do a lead hazard assessment if the home was built before 1978.
Right,
So I think it's somewhat limited in terms of what the
Yeah.
Environmental Health Department
Yeah.
is testing for. I guess I'll just make a few comments. I think, like, from a kind of community planning perspective, I think you have to, you know, you have to figure out what the acceptable level of risk is, because, you know, we have communities, and there's, you know, a lot of things that contribute to quality of life. A lot of the legacy contaminated sites in our community are, you know, in our urban area. We benefit from being able to walk and bike, you know, being able to easily access childcare and schools and stuff like that. So I do think that there is, you know, there's trade-off. There's a lot of sensitive populations that are in places that have had historic contamination in the past, and that's not ideal, but it's also kind of the reality that we are living with, and kind of how our communities have evolved over time. And it's true, we can't cut off those boundaries at zoning boundaries or municipal boundaries. It's all, one community that we have to work with, and.
I think, the other thing, I guess I'm also, moved by the fact that, I think everybody on the commission agrees that this is something we're needed. But for me, another thing is that our industrial parks are populated by professional office buildings with people working 8 hours a day. And some of those same people, while they're not children or maybe the elderly, they're there all day long. And so, I guess I'm leaning towards allowing this, and that's just so everybody knows.
I think it's known that I am in favor of all of it, and, we have industrial butting up against a professional office. We're focusing on the industrial, but under this, a child care center would be allowed in a professional office setting. That's 200 yards away from, we're talking about this one just because it's, current. I don't see a huge difference in it. I mean, we allow some professional office setting in our industrial districts. I don't think a child care center changes that. And then when you start looking at child care centers, when you're talking, or educational facilities where you're talking 30, 40, 50, 60 kids, where do they go? You're not going to be building a facility in a residential neighborhood for that. You're going to be looking for a professional office and looking at the zoning. Where do you go on that here? I feel like the only spot in this township is starting to expand in the industrial area. And going back to my other point, seeing that it's largely, undeveloped lots, the risk to me is very low. Not to say that there's not a risk, but the risk is there now with the surrounding residential neighborhoods and the existing schools.
With the recommendations, if we were to approve something like this, and I'm playing devil's advocate, what are the risks if a child care center went in to an industrial park and years down the road there is a contamination? They did a phase 1, okay? They didn't do a phase 2 because there was no known risks. However, maybe they would have found something, but if it's only just one sample, once a quarter, and they just did, a couple samples, most likely they wouldn't find it. But what would the risk be to the commission, to the township, if we were to approve something like this and it did potentially cause harm in the future? Understanding that a person is purchasing potentially a piece of property and they'll have to have licensure by the state, insurance, liability, all of that on their own merit.
I guess I would be interested in Abby's perspective. I don't think the township would necessarily have liability. I think the bigger concern would be to the health and well-being of the children. Yeah, I think the township is generally protected, but I would hear what Abby has to say.
Sure. So I'm sure in previous discussions that you've had with your township attorney through the years, there's been this idea of governmental immunity. So municipalities have a certain level of immunity in the actions they're taking. In this instance, I'm going to be a lawyer here and hedge my bets and say that you're never risk-free in any scenario. There could be a factual pattern that I can't think of off the top of my head that would expose you to some liability. But really, when we're looking at scenarios of environmental contamination, they're mainly focused on getting the sites cleaned up. And it is typically the then property owner that is responsible for cleaning up a location. And then there are complex rules about whether they can go back historically and hold others responsible. But that's kind of the baseline framework that you're looking at, that the township is not the owner of the property or the one responsible for the release of a hazardous substance. So you're well protected in that sense, and then you have that additional layer of governmental immunity. That's not to say that you would never be in a scenario in which, you know, someone out there wouldn't threaten that type of action, but that happens frequently for municipalities in which they're threatened with certain types of action or something's actually brought, and then it ends up, you know, kind of dying on the vine due to those protections put in place.
Mindy, I'm waiting for the challenge.
I don't know if I want to go there, but
You have to be open and honest and fair.
so, and under Part 201, liability protection is only if you do a baseline environmental assessment. If you are found to have a facility condition on the property and you haven't done a BEA, you are a liable party, which is different than what she just said. And then I also will go to the fact that she was talking about if you find contamination, you want to clean it up. Well, there's another thing. Even if the contamination on your property is from an off-site source, under Part 201, you have to protect those on your property, and that protection includes making sure you don't have a fire and explosion hazard, making sure that you're protecting third parties, and you're protecting those that are on your property, you're giving access to the state when they need it, and you're making sure that any deed restriction on the property is being allowed for. So the question was, what was the township's role? And that's where I do have a concern. Telling somebody what to do to make sure that their property is clean. I don't think that's the role of the township.
I would agree with that. I don't, and you said it earlier, I don't know that we as a commission should be responsible for dictating
What to do.
what to do. I don't, I think it, I don't know if you said something about, how'd you say it, with the, you know, risk.
Determining what the acceptable level.
Yeah, acceptable level of risk. Who gets to decide that? I don't think it should be us. I kind of go back to the owner or the buyer or the person running the daycare or the, whatever it is.
Or the parent.
Or the parent, exactly.
Yeah.
You know, I mean, do you ask the parents of a daycare in a home if they've tested for radon? I mean, no, we don't. But that's my point, is that I don't think we should be the ones to decide that. So I guess that's why I'm leaning more towards allowing them in the industrial, because of the need we have here, and it's so hard to find places to put a daycare center. It's just, so, I don't know. And I like the idea of putting, restrictions is the right word, or conditions. I like the idea of doing that if we can come up with something reasonable, but if, it doesn't sound like any of the conditions are good with, you're just against it, so.
The proposed standards?
I guess,
In
yeah.
the
Yeah.
sample language that was provided?
Yeah. I mean, we can tweak them if we feel we need to, but I just, I guess if you do all of this, and then you put it back onto the owner, buyer, whoever, and they have to, you know, there's, what do you say? Acceptable risk. I like that word. You have to decide what is acceptable to you. I mean, there's got to be some kind of individual responsibility. We can't protect everybody, and that's not to be insensitive at all, but I just feel like we can't. There's no way. So.
We can establish what our standards are, and we can establish what we would be requiring for, in the due diligence, to ascertain that the site location is, let's say, as free as it possibly can be, for the protection of the, well, let's say the clients that are going to be using it. It just so happens that the clients that are using that are children. And first and foremost, our duty as a board or a township is the protection of the citizens. And I think that again, we can certainly establish, when we say we can't tell somebody what to do, but we sure as heck can establish what due diligence should be done to assure ourselves that this property is, or at least this site location, is in fact suitable for what it's going to be. The only thing that, and we have talked about different areas that a school is next to some area that we have found out today that now there's some issue. But what I do have a problem with is that when you are in an industrial area and you want to have some type of facility, you know automatically that the potential for something is a lot higher simply by where it's going to be. So again, I have that conflict in wanting to do something, but at the same time, I have a conflict to where it would be. And I guess when you start repeating yourself, that's not a good idea. So, is there any other comment, thoughts? Okay.
I mean, what is the harm, I guess, since the sensitive area is the industrial, is there any harm in putting it in the industrial district that at least a phase one would be done? To at least kind of find a happy medium there?
Oh, I would think that not only is there responsibility on the township to make sure that we are establishing the procedures and the standards to make sure the facility is, or at least the site is okay. But then I would think it is incumbent upon whoever's going to be the owner putting that through would actually do even more due diligence to protect themselves and protect the clientele. I mean, that would be, at this point, we would hope the minimum that people would do. So, it always comes down to, eventually, the township can only do so much, but it always comes down to the individual.
So are you saying, Paul, that you would be comfortable moving this forward to a public hearing if the zoning text amendment specified that a phase one environmental assessment was required?
I was looking at the language, excuse me a second, let me find it. And this was the revised language.
This draft zoning amendment?
Yeah, I got all this paper all over the place here, let me see. Yeah, that's the letter, oh, here it is. This language is acceptable in that the planning commission shall have the right to require the applicant to undertake environmental due diligence to determine whatever the hazardous substance is present on the property. So it gives us flexibility as to what type of minimum requirements we would have on this language.
For each special land use permit, correct,
Yeah.
Claire? So in
Right.
this case, we'd be looking at individual applicants for a special land use permit and then making decisions.
Yeah.
Doesn't that kind of run the risk of making decisions?
So I can give you a little background of how this came here. So the original, they started with saying that kind of the highest gold standard or the more expensive standard would be an environmental, a phase one environmental site assessment. And kind of what they found was that a lot of the concerns related to what the contaminants could be might not be discovered in the phase one environmental assessment. So the recommendation was kind kind of testing for this more sensitive population, looking at some of the air quality, the soil concerns would be better picked up by someone with expertise in phase one environmental assessments, but might not need to do the, specific procedure for that phase one that there are. So I think that, and Abby can speak to it, the approach that they're recommending, but it would allow the Planning Commission to flag if there's any concerns about surrounding uses, about the history of that use, to say, you need to hire someone with expertise and provide X, Y, and Z testing based on recommendations of an outside consultant, environmental consultant. Abby, do you have anything to add to that?
Sure. So basically the recommendation was based on the comments of the Planning Commission as a whole, in which, with all decisions, there's kind of a spectrum of people's level of comfort or their ideas on what should be done in particular instances. So on the one end, you can have someone who would like to have one of these centers in an industrial zone approach you. And in that scenario, the commissioners are relatively well aligned that they don't think that any due diligence is needed. That would be, at your discretion. You could have a scenario in which you have some serious concerns or questions and you want to require further due diligence. But, Mindy has a lot of experience in this area, and as she's pointed out, limiting it to just a phase one or having some sort of bright line rule that you're only going to use a certain method, and if they check that box, they're fine. That does leave open the potential that something might be overlooked. So instead, providing the commission with the discretion to require due diligence gives you the opportunity to limit it to a phase one or to have them look into other considerations. It just provides you with more options on what you would like to see an applicant pursue, and hopefully recognizes that just limiting it to a phase one, as people have mentioned, so that if there's no historical data, then that would be a potential limitation in that scenario of only requiring a phase one. And it still links back to those state standards, though. There have been comments about whether the Planning Commission is the appropriate body to set standards. This language, again, links back to what the state already has in place. And what they develop over time as more research is done in how they modify that. So you're leaning on the state agency and body that deals with this every day, instead of, as planning commissioners, trying to identify, what hazardous substances are we going to say no or yes to and what levels. So the language is intended to cover, multiple viewpoints and allow you as a body in each scenario to evaluate that, do that risk assessment of what has been historically at this location that we know of. Do we not know anything? Do we think that there needs to be more investigation? But also does not tie your hands in trying to be the arbitrators of what is safe and what is unsafe, in the sense that you're relying on that state law framework.
In this issue, we have discussion of possible action. I'm assuming that the possible action is to vote up or down with respect to moving this to public comment at a future meeting, public hearing at a future hearing. And I think that there's enough here that we are, trying to, that I'd like to hear what the public would have to say about this. And so from that standpoint, I think I would be in favor of moving this forward to a public hearing.
Could I make,
Go ahead.
Well,
go ahead.
I was just going to make one, I think that the point that the facility needs to be better defined was a good one, and so we can make that tweak to the language that gets posted for public hearing if that's what the Planning Commission wants to see.
Yes.
I would suggest, Claire, that one way to do that would be, instead of eliminating the word facility from the ordinance text, just amend number 1. The amend, for the added text, the use is prohibited at any location that is a facility as defined by blah, 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 whatever it is.
Okay, thank you.
Okay, do I hear a motion?
I make a motion to move this towards, public hearing based on the modifications to the term facility, based on this draft that was provided to us.
Second?
Support.
Okay. Moved by Steve to move the consideration of the zoning amendments of the daycare center with corrections to terminology of facility for public hearing at the, would that be the August meeting?
Yep, August 1.
August 1st meeting. Okay. Let's take a roll call.
Okay, Ferguson.
Yes.
Richardson.
Yes.
Walters.
No.
Gonzalez.
No.
Wassam.
Still on the fence, can I abstain? Yes.
Excuse me?
Yes.
Edley.
Yes.
Okay. It has been approved 4-2 to move this to the August 1st planning meeting for public comment. Thank you. Thank you very much.
Can I just make one additional clarification? The public hearing will be posting this draft language in addition to what was presented to you last month, which is the realignment of the districts.
Yes.
Okay.
Thank you.
Okay. Yep.
Okay. All right, moving on to the next item, which is the minor amendment for the Alexandria Hotel.
Okay. So, let's see, let me pull up my staff memo real quick. So as you will recall, the Planning Commission approved the Alexandra Inn back in April of 2022. A land use permit was issued in August of last year, and construction is complete. They're now in operations. Operations have begun. So in May of 2023, the Board of Trustees approved the zoning amendment related to parking standards to allow more flexibility related to parking. And so the applicant is here, and they're seeking approval of a minor amendment to the approved site plan to allow for public, which would be non-hotel guests, the use of the rooftop dining area. So we took a look at the rooftop dining area and the square footage, as well as the hotel parking requirements and staff parking requirements. So based on our ordinance, we have requirements for a certain number of parking spaces. However, there's flexibility, and the recent amendment allows for a reduction in off-site parking based on the following criteria. So you'll see on page 33 of the packet, I go through those criteria. So the dual function nature of off-street parking spaces where operating hours for parking needs occur at different times. The number and frequency of walk-up or foot traffic customers. You'll see, I note that there's 8 hotels within approximately a quarter mile of the Alexandra Inn where there could be walk-up guests. There's additionally 3 hotels under construction. Additionally, as stated by the applicant, all employees currently bike or walk to work. Another consideration is the availability of shuttle service and transit. It's located right on the Beta line, the Bay Line, which is the most frequent service in the region currently. And that service is heavily used in the summer by tourists as well as locals. The seasonal nature of operations is also a consideration, and I do think that allows some benefit to the property owner and the hotel owner to allow, during the shoulder season when it's still reasonable weather to be outside dining, to allow for, at their discretion, allow for non-hotel guests to use the rooftop dining based on occupancy of the hotel. And then the last one is bicycle parking spaces. So the Alexandra Inn has purchased 18 bicycle parking spaces. That allows for a reduction of 4 parking spaces. I think right now, are a lot of people biking on that corridor? There's some, but it's not, it's not the numbers that I think we're going to be seeing in the next several years. I think we are going to see more bicycle traffic as we improve crossings, improve connections, and improve bicycle amenities with our beach district planning process. And then the other big consideration, I think, is just the estimate that 60% of the total diners would likely be hotel guests. So, requiring that double counting of parking, which is what our ordinance currently requires, is pretty rigid, and I think that it doesn't necessarily reflect the market. The other thing that we've heard from multiple hotel developers is that our requirement for 1 parking space per every 1 room is not necessarily reflective of the market, the current market. They estimate that they need 4 parking spaces for every 5 rooms based on, airport shuttles, families booking multiple rooms, those types of things. So I do think that this added flexibility is in line with our ordinance and our master plan, and so I'm recommending approval of that. And the applicant is here as well. Allie Warfel is here.
Coming up?
Claire, are there any questions you want me to address?
Could you please identify yourself?
Alexandra Warfel, 1865 Maple Drive. I'm happy to answer any questions if there are any from the board, and appreciate you guys hearing us today and considering our minor amendment.
Just one question. Back in March 1st of last year, when there was a discussion as to the hotel itself, and comment was made that the rooftop area would be for the hotel guests only. Was that at the time envisioned as being a restaurant, or was that more of a facility to, as it was stated, like the veranda?
Right, and since our initial meeting with you and then our approval meeting, I went back and watched the videos. And I think we mentioned that at our discretion, we would like the public to come in, but the minutes reflected that it stated for guests only. So there might have been a little mix-up there. The intention the whole time for the rooftop was to provide some food offerings in addition to a space for guests to enjoy, or in this case, public members potentially as well, that was outdoor and not on the beach. As you all are familiar, the site is fairly limited, so captivating that space on a rooftop area allowed us a lot more amenities to the property. And then we also came to the board as well for recommendation to the state of Michigan for our liquor license. So the, again, assumption was that we could have a bar up there as well.
Okay, thank you.
And I can maybe add in just a little more narrative. We've been open since Friday, which is very exciting for us. And I was communicating with Claire about a month ago about our projected, usage of guests versus non-hotel guests on the rooftop. And we'll say that those numbers may be a little conservative, just how business has run so far. Nearly every single hotel guest that has stayed with us has been up there at some point during the day. So we've seen a lot more interest than we imagined from hotel guests using the space, and we are limited from a building code perspective to only 49 occupants on the rooftop. For 1,400 square feet and 49 people, that's a lot of space per person. So we could, if we weren't limited, fit a lot more people than we technically can. So our occupancy for that rooftop will hit full a lot faster than you would think just looking at it. So I do anticipate a lot more hotel guests using it than when I mentioned that 60% to you, which is great for our guests. But if people aren't there, it would be nice to have the flexibility if it's empty and, you know, a Monday night when not a lot of people stay at hotels to allow East Bay Township residents or other members of the public to come stop by as well.
Thank you.
Josh Werfel, resident of East Bay Township and property owner. Just adding to that further comment, based on all the properties that we have owned within the East Bay Township, guests typically from noon to about 8 o'clock leave the hotels, doesn't matter which hotel it is, but they leave and they go and enjoy the surrounding areas, where what we're seeing is that the township residents' phone call traffic is coming in at that point in time because they're coming out of work and they're looking for a place to enjoy the sunsets in the evenings. They don't need to go to the surrounding areas for that. They're looking for something in their community to enjoy, which we haven't been able to provide to them because we're not open to them. So again, hitting both marketplaces and utilizing the space effectively is what we're after. We don't see the double counting because we're going to see the guests leave and go enjoy the wineries, go enjoy the Seabury Sand Dunes, where the locals are going to come out of work and looking to enjoy an evening meal, cocktail, and overlooking the water. A little bit different, two different demographics that we're trying to hit.
Thank you. Call.
Oh, I'm all for it.
Yep.
Is there other discussion?
My only concern is the park next door, making sure that they're not using the park as the parking lot.
I can maybe address some concerns with the Jens Park next door. Just in terms of our property layout, our side doors, which one of those does neighbor Jens Park, are key card entry only. So you actually have to have a hotel key to get in. The only door on the property that is unlocked is at our front desk, and our elevator is viewable right next to our front desk. So there's no real way someone could enter the property without coming through the reception team. And for guests, we are only 32 rooms, so we have a fairly good understanding of who's staying at the property. So it's pretty easy to notify someone who's never been in there before because they are looking for the elevator or looking confused, and we can get a pulse on guests versus non-guests very easily, and also communicate with the rooftop if we're at capacity, or ask them, do you have a parking permit, which are our pink parking permits, and where did you park? Can we help you find anything? So opposed to other properties who have a door from the beach or doors off the side entrances that aren't locked, we can help navigate that traffic right through our reception team.
I think it's also, appropriate for the park to start a little bit more signage, that I think it can be doable. It's just my initial gut reaction concern, but I think we can deal with it.
I like the idea.
Yeah, me too.
Okay.
I'll make a motion to approve minor amendment to SPR 3-22 Alexandria Inn to allow for non-hotel guests to use the rooftop dining patio based on detailed information provided by the applicant. Email correspondence dated 6/13/23 and staff recommendation dated 7/5/23.
Support.
Okay. All right, moved by Call, supported by Rhonda to approve minor amendment to SPR 322 Alexandria Inn. All in favor?
Aye.
Opposed? Okay, thank you. Okay, last item is the row investments on the possible public hearing and discussion for the hotel, the apartment building. Claire?
Okay. So So this is a 27-unit apartment complex. It's on about 3.5 acres, located, as I believe you all are aware, looks like you all attended the site visit, just off of Holiday Road. It's a use permitted by right in our zoning district. It's zoned high-density residential. Tonight, I'm not recommending it for approval at this time, so it'll be public hearing, but there are some outstanding items that are outlined in the staff report. We're still waiting for Grand Traverse Metro Fire review and the Road Commission review. The stormwater, I'm looking for a complete stormwater permit submittal. As I think you are aware, the applicant began excavation without a permit and were issued a stop work order. So we're looking for just a complete plan set for that stormwater permit. Looking for updates to landscaping and irrigation plans to meet the ordinance requirements, an update to the parking dimensions to meet ordinance requirements, which the applicant has said that they will provide that. And then just looking for elevation profile of the proposed carports, which is pretty minor. There's also a few recommendations in the staff report for Planning Commission consideration. These are not, black and white ordinance standards, but they are best practices. One is just that the property to the east is less intensive than what's proposed. And there's a standard in the ordinance, and I can't remember the exact section, but specifically says that I think it's in the landscaping section, that if it's a less intensive use nearby, there should be additional screening. So I would recommend screening evergreen plantings with a minimum of 6 feet in height of the tree height and 10 feet depth of screening, just to create that visual buffer between the two properties. And I also did just want to take this opportunity to highlight a few areas of our zoning ordinance that's being worked on that I think is a great opportunity for moving forward. So one is that unfortunately the site was clear cut by a previous owner, not current owner, without any consideration for the layout of the existing trees. So I think that as we amend our ordinance, having a requirement that you can't clear cut without coming in with a detailed inventory of the trees of what you're able to conserve based on placement of buildings is going to make for much better site plan submissions. So I'm excited for that opportunity. I think this was a missed opportunity, but I think that our ordinance rewrite will address that. Just if I can real quickly highlight a few others that our ordinance is going to be addressing. Another is setbacks in between more intense uses. So right now we have a 6-foot setback requirement. So theoretically, buildings can be 12 feet apart in high-density residential in 2 different developments. So that's very close. And so the way our ordinance is drafted right now, we have a provision for major and minor buffers. Something of this intensity would have a major buffer, which would include berms, walls, and dense, like conifer plantings. We're updating all of our landscaping standards, which would require landscaping surrounding the buildings and the carport. Right now, we don't have any specific requirements for where the landscaping needs to be. It's just total landscaping. And the applicant does meet those standards. Our new standards we're looking at adding parking lot landscaping and islands, looking at adding requirements for street trees, native vegetation, and also sidewalks for pedestrian interconnection. So I think that, I guess from my perspective, the site plan does, in most instances, meet our minimum requirements for site plan review, and it is a use by right. There are some areas that I'm still looking for more information, but I do think moving forward, we are going to be better set up for facilitating the type of development that reflects our master plan.
Thank you. Okay, why don't we open the public hearing on this issue at 7:59.
My name is Elizabeth Black. I live at 3441 Holiday Road. I'm a property owner there, and this is the property, low-density property spoken of by Ms. Carner. So Mr. Gonzalez and the Planning Commission and Ms. Carner I'm here to share my perspective as a resident of East Bay Township with the board, and I had hoped with Mr. Jarrow, who I understand is not here, the developer. You are here, okay. As I sat on my deck anticipating this meeting and considering how to best convey how your actions have on this property have impacted me and our neighborhood, I stared at the almost two-story sand dune that has been created next to my home. In my life, I've learned that the best predictor of future behavior is past behavior. And the developer's behavior, and I understand there was one before you, their actions as a neighbor to this point have not been promising. This property was a fully wooded lot in the midst of acres and acres of wooded lots in a township known for woods, creeks, fresh water, and a long legacy of appreciation and regard for the people, wildlife, native plants, trees, and the watershed they contain. My parents brought me to this area in 1964. As I grew up skiing almost daily at Mount Holiday, I watched with interest at the buildings of new homes, even at 6 or 7 years old. There were many added, but always set amongst the many trees, ferns, and the huckleberry bushes, so that the character of East Bay Township was maintained. This was done to the extent that you never quite realized how many new buildings were added, because the woodlands remained the main focus. Additionally, the animals remained, and we've actually increased the number of species in our neighborhood since then. Fast forward to the past couple years, the residents in our small cul-de-sac of 8 homes, half of whom are here today to speak to this matter, have always known that the lot at Maplewood and Holiday was for sale and likely would be built on. What we didn't expect was a clear cut of trees suddenly in a few short days, from road to property lines, taking every single tree. Overnight, it became like the destroyed rainforests of South America and the Amazon. It broke my heart. There were raw stumps and dying vegetation, with deer literally wandering around not knowing where to go as their woodland home was gone. The property remained in the state for months. Then the wasteland was finally cleared and it became a lot of empty soil. Eventually, the stumps were cleared and grass was planted and began to grow. The deer came back to graze for a while. We had a pleasant meadow. But then last year, the bulldozers returned and moved hundreds or possibly thousands of yards, I don't know, of sand to form, I'm not sure what, but what I now call the Holiday Hills sand dune. All winter, your sand blew into neighbors' yards, the wind eroding the hills with no vegetation there. In the spring, I was literally sweeping piles of sand off my deck. This past behavior, since the first tree was felled, and since you have taken over the property, has not been that of a good neighbor. And so I am wary of future behavior. I know there are many considerations in planning of this type: drain field setbacks, fire access, and more. I am not a builder, nor a developer, but I am a citizen of this township, a neighbor, and a member of the Greater Grand Traverse area for almost 59 years. I know what caring and consideration look like, and these developers' actions are not it. Mr. Jarrow, you've destroyed not only beauty and habitat for the people, the animals, the ecosystem, but you've also destroyed trust. You now ask to be approved for a plan, which I have looked over the blueprints, for buildings, garages, and drives that stand directly behind the walls and windows of our bedrooms, our family rooms, and our back doors. Following tonight's site visit, I know that Mr. Jarrow is attempting to put 27 units concentrated on only 2 acres, which I'd like considered. These structures and pavement are butted up to the property line with drives at the property line. You want to place more homes here for a potential of over 50 people. Have you considered the impact on all of us?
Excuse me, could I ask you to finish up,
I am
please?
almost finished, yes.
Thank you.
On our association, have you considered it? The plan notes an existing tree line. There is no tree line. There are no trees. Your predecessor took them out. They're left a few wispy saplings. At this moment, within 20 feet of my family in our bedrooms is a 1.5-story sand dune. It literally touches the property line. And with buildings on top of it, how will the water run off? This is a main concern that I think you should be concerned about as a board. Building and running a business that you desire to be profitable is your right, but you also have the responsibility and obligation to leave behind a healthy and productive set of buildings and land. As we now move towards months of construction and yet another step toward the great change and impact on our neighborhood, I ask the Planning Commission and Mr. Jarrow to carefully consider, identify, and implement a plan for this property that places buildings and blacktop in a manner that has least negative impact for all residents. And I vehemently request this developer is required to take the most action possible to replace and repair the plants and trees that were decimated in the hope that with time, some of the woodland habitat and character of this cleared property can come back into existence. Thank you for your time.
Thank you. Anybody else? Okay. I would remind you that we usually are limited to 3 minutes.
Okay.
Thank you.
My name's Kenneth Bonner, and I have a question. It states you can have 8 units per acre. There's a little over 3 acres there. Does that mean you could build 27 units all on 1 acre? Or is it, is it designed to be spread out over that whole 3 acres?
I can answer after the public comment if you want.
Sure.
Or now.
By all means, yeah.
You want me to answer now?
Well, we'll see. Anybody else?
Yeah, I got one. So I'm Dugan Diamond. I'm a part of the board of Maplewood Hills Condo Association up on Emily Lane. And I'm here just to kind of bring a couple points, a couple of which you mentioned the trees were clear cut, and I believe that they did end up coming onto our property a little bit, so we also would like to see some of the trees come back if the developer were to move forward with this. Another couple points, we do have an erosion issue that we have not had the entirety looked into yet. We had it assessed about 4 or 5 years ago prior to me becoming a board member. And we are very concerned that if the land below us, because we are directly above, this site, we are very concerned that that's going to cause further erosion issues since we have not had the opportunity or the financial means to settle this. And then lastly, the last point that we were worried about, we're worried about the sewer system as well, but that kind of plays into the erosion. But lastly, Maplewood Road, and I'm sure most of you are aware, that road is not in very good shape. It's littered with potholes. And if we were to have heavy machinery and, excavation and the whole 9 yards, that would just deteriorate the road further. And I believe prior boards of Maplewood have came and presented to you in the past. I'm not entirely sure when that was, but we would like to see that road repaved, or at least better maintained, structured, because it's literally falling apart, and we're having multiple potholes open up every spring and winter time. So those are our concerns. They're certainly entitled to do what they want with their land, but it is going to affect us to some small degree, and at the very least, we would like to see a retention wall put in and some more trees at the top of our property, as well as our other points considered. Thank you.
Thank you. Is there anybody else? Okay. Seeing none, we'll close the public hearing at 8:08. Take it back to the board.
Well, it seems like we're waiting on several things.
Mm-hmm.
I mean, is there, do we even want to go forward with discussing the site plan without stormwater permit, without GT Metro Fire review?
Yeah, absolutely. The applicant is here.
Oh, okay. Okay. Before you, please come up, but would you please answer the question that was posed on the,
Yeah, so the way that our ordinance defines density is that it's for the entire site. And so if you have a 3-acre site, you would be allowed 24 units for that entire site. So if you concentrate them in one area, then the planning commission looks holistically at the whole site, looks for, buffering, adjacent uses, those types of things, but there's nothing to say that they need to be interspersed evenly throughout the entire site.
Yes, sir, come forward.
My name is Jesse Mitchell. I'm a surveyor and engineer working for the owner. Address is 3356 Jackson Road in Kingsley, Michigan. So Stan, the owner, Stan Jarrow, contacted me after he was issued a stop work order. He was under the understanding that he had all things in place to start his dirt work activities. And not all townships have dirt work ordinances that require a stormwater permit of sorts to do dirt work. So he didn't think he was doing anything wrong, Anyway, so he contacted me once he got the stop work order, and we started working through the ordinance. We believe the plan that's put forward, and Claire has reiterated it, it meets the ordinance. There's some minor tweaks or clarifications. Claire has asked for some simple things to be added, and we're adding those. We've spoke to all the other agencies. There's really no issues arising anywhere. And most of the comments that came up tonight were probably really not appropriate for this meeting. Those probably should be discussed at master planning. This property is zoned high-density residential. So when you have a high-density zoned property, there's going to be a high impact when the development happens. So 8 units per acre is a very high zoned parcel. So he saw the property, how it was zoned, and is pushing the plan forward based upon how the township has zoned it. The property has sewer and water. Not all properties have that. So you can't just go anywhere and build an apartment building. This property was planned for an apartment building. Now, on the surface of things, people are very upset about the trees getting cut, but if that is something the public wants to happen, they should bring those things to master planning or make action on their part to preserve things. So we believe the plan meets the ordinance. We're not plan on having any issues with any other agencies. So if there were some questions or clarifications to move this forward, I understand you might not be able to approve it tonight, but if there was anything that Claire hasn't, anything additional that Claire didn't mention that you need to bring forward, we'd like to hear it now so we can get all of the checklist items back to Claire and get this approved hopefully at the next meeting.
Thank you. Call.
Oh, no, I'm willing to hear what other people have to say.
So the site was cleared not in relation to the applicant or the owner? It was done by a separate?
It was cleared by the previous owner.
Okay.
The earthwork was done by the current owner.
Okay.
But the site is currently in compliance with soil erosion. They have a active soil erosion permit on file, and is, in my conversations with the health department, is in compliance. And I just mentioned, so the items that I mentioned, that we have a full draft of our zoning ordinance right now. We've got, and I apologize to make you the example, but I just did want the planning commission and the public to know that we've gone through the master planning process. We've drafted the ordinance. It's ready to go. It's just not in place yet. So I think that it's helpful to just see a specific site and kind of see where the ordinance that's currently drafted will benefit future sites.
But they're going for the way it's currently.
Exactly, yep. They have
currently
to
written.
meet the current ordinance standards, and the staff report that I put together goes through all of the current standards.
Gotcha. And since this is a use by right, once they follow these conditions, it has to come back to us? Am I understanding that?
Yep, it's a use by right, but it still requires public hearing and approval by the planning commission.
Okay.
So this is the public hearing, but the planning commission would need to approve it at a future meeting. I would be curious just on the planning commissions. I think the biggest item is just the additional screening recommendation beyond that is, links back to a standard in the ordinance. It's not a black and white standard, but it's at the planning commission's discretion. I think that providing some additional screening, given the property to the east is zoned high-density residential, same as this one, but there's only 8 units there, so it is a lower intensity use. And I think that providing some additional screening would be in line with our ordinance.
Were the stakes that I'm asking the applicant, were the stakes we saw on the property today, that was the building footprint?
Yeah.
So it kind of bisects one of the mounds currently.
Yeah.
So the earthwork is not actually...
The earthwork was started with, I'm not really sure, I think they just, Steve Bosch was like, well, we need to start carving it in, and they didn't have an exact plan.
And is that something that the applicant, and right now, are you right at the setback line with the building footprint? 6 feet from the property line?
We're 12 feet on the closest, and the other one is approximately 30 feet. So, in discussions with the buffers with Claire, with the setback is 6 feet. So I discussed with her, we could get the building back to 12 feet and provide 10 foot of width in vegetation. Without having to modify the blueprints.
Right.
Because we can shrink the building down, but we would lose one of the features of the building. There's interior storage lockers, where we're taking 20 foot of the building and having inside storage.
Right.
For each occupant. So we could eliminate that. But she said, essentially, the ordinance can't mandate it. So our preference is to keep the storage lockers in place and provide 10 foot of vegetation.
And so I think the concern here, probably amongst us and maybe from what you heard from the public, is that there be some kind of visual site buffering. And is that something, our ordinance does not require the evergreen trees, is that correct, Claire?
You can require them because
It says you can require screening if there's an adjacent land use that's less intense. So it provides some discretion for the planning commission to make that determination. I would recommend some visual screening.
I think just given what, at least from my perspective, what we saw today, and just the closeness of the buildings to the property lines to the east, up high, and then also given the slope at the high side, that would be the north. Northeast. I think some additional screening would be nice both for the neighbors, and it could possibly also reduce some erosion concerns that also the neighbors expressed to us, at least at the site today.
Yeah, so we could, one thing that will happen is, that was probably an 80-year-old regrowth in the clear-cut forest. So there hasn't been any thinning in the forest, so a lot of the trees haven't been getting sunlight. So there is about a 10-foot buffer left there. The trees are pretty spindly. Those will fill in, but we could easily incorporate, where the structures are, potentially adding an additional tree every 10 feet that's already established, spruce, and build that into our landscape plan.
Yeah, I think, the 10 feet was the width, so, yeah.
And there's
Of that
already some
tree.
greenery there.
Mhm.
And the trees, when you plant them, aren't 10 feet.
Mhm.
So they're going to fill that.
Wendy?
So you weren't out there when we were out there for the site plan. So my question is that you've got the upper terrace and then the lower terrace, and then you got the very low area. currently, what is the finished floor elevation compared to what the terraces are right now? I mean, I can read what the finished floor is proposed at, but I don't know what's out there currently. It says 799 on the top and 787 on the bottom, but what's out there currently?
Well, a lot of grades, what's out there is not flat. I guess to give you an exact cut-fill ratio, if you take it in reference to the proposed approach, where we're gonna line the road up to the road that's across the street, there was a stake there that said driveway.
I don't remember seeing that.
Where people have been driving in, you actually gotta go down towards the pond as to where they've asked
Okay.
us to permit the approach. So it lines up with the other one across the street. So that grade, you can see, 777, the first building is about 10 foot higher than that. The lower building is about 10 foot higher roughly, or a little less than the approach. And then
Pretty close to what was there.
fairly close, and then the next
Right.
building, is close to the average of that same grade, but that next building is gonna be another 12 feet higher. That's the only way to get the site to work. There's about 75 feet of elevation on the site, so it's not flat.
And what is proposed on the north to stabilize that?
Just grass, seed, mulch, and we're replanting it with trees. But essentially, just standardized stabilization methods work fine on sandy soil. So if you have clay soil, you get a lot of runoff. If you notice, there really isn't a lot of movement out there, because when it rains, the water just goes straight down. It's clean soil. So as soon as the dirt work's done, the contractor will add topsoil, seed, and mulch, and it stabilizes itself with grass. And then, they go through and plant trees.
So have you talked to the condo association to the north and what their erosion issues that they're talking about?
No, and I, as an engineer and surveyor, I did all the field work and inspections, been out there many times. I didn't see what they were referring to. And maybe it's on the ditch line, where the ditch line heads up into their property. Their development is much higher in elevation to the ditch line. That may be the spot.
Is that the Emily Lane that you heard the?
Yeah, it gets this one up here on this, I don't know what page I was looking at, the aerial.
Yeah, the public comment to Emily Lane.
Yeah.
Okay.
Thoughts? Rhonda? Do you have comments?
No, I was just clarifying.
Okay.
I'm good at the moment.
I mean, I think we're all, to see like a final landscape plan to see what they're doing and making sure all the other conditions are met based off of staff. I think that's where we're at.
Okay, so at this point, we will just
I need a motion to
table,
table or,
yeah, or is it table or postpone?
I don't know, I gotta find it.
Either one is acceptable.
I'll make a motion to table SPR 623 Row Investments. At an appropriate time when all the rest of the information needed by staff is available.
A second.
I'm sorry, who? Second? Okay. Okay, motion by Mindy, seconded by Steve to...
Before we vote on that, did you say to an appropriate time? We're not giving it a date at this point?
Yeah, because it's not under our control, it's in other people's control.
Okay. Okay, just needed clarification, thank you.
to postpone to a later date. Okay, all in favor?
Aye.
Opposed? Thank you. Okay. All right, we're at that next point, which would be public comment on anything for discussion at this point, and I think it's be about, what, 8:30?
8:25.
8:25, thank you. My phone died. There it is.
Oh, come on.
I was going to say, wow, that's going to be interesting to hear what you have to say. Okay, is there any takers? Going once, twice? Okay, we'll close the public comment at 8:25. All right, thank you. All right. The next meeting that we will have is on August.
I added a new item to the agenda.
All right, consideration of future agenda items.
And I added that, I think I would like to have this as a standing item, just because if there is public comment and there's planning commissioners that are like, it gives you the opportunity to direct staff to say, hey, can you take a look at this item? I think this would be interesting, so that you're not responding during public comment, but it provides you with the opportunity to direct staff to take a closer look at any issues that have been brought to the attention by members of the public or, elsewhere, just that you've noticed in the.
That was a good idea.
Yeah.
Okay, does the board have any recommendations to staff for future items to investigate? Seeing none, that's why I skipped it. Anyway.
Not yet.
Okay. Our next meeting is August 1st. It'll be a regular meeting, and then the zoning subcommittee is called. The zoning subcommittee next meeting is July 19th at 8:30 in the morning. And with that, we will adjourn. Thank you.